Um, and then we asked for number 46, which is the documents supporting their actual expenses, checks, invoices, bank records, or any document regarding the amounts you paid. And we limited it to this project.
Let's do this. Let's break this down request by request as opposed to going through all of them at once. So let's go back to the last two requests. Let me hear the response to that, why you guys feel that's overly broad.
Your Honor, thank you. John Slates for Hill and Wilkinson. So the issue here relates to the profits. Profits don't have anything to do with a defect claim. Profits don't have anything to do with what they're calling a liquidated damage claim. And I'll say this, the cases that address liquidated damages address them in the context of an owner's rights with respect to recovery of damages if the project is delivered late. They're characterizing what was an agreed fixed rate as a liquidated damage. I understand their argument, but I think it's an important distinction to say it's completely out of context with the case law that has addressed liquidated damages. I'm not aware of any case that has characterized a fixed labor rate as a liquidated damages. If we were to characterize fixed labor rates as liquidated damages, we would create a whole new area of law, really, that I've never seen before in 28 years of construction practice. So there is that. With respect to them having the ability to verify what those actual costs are. First of all, as I said, the contract provides that it is a fixed non-auditable rate. But in addition to that, during construction, we had change orders, and some of those change orders had general conditions costs in them. And this is what they're referring to as a liquidated damage. And during the project, the owner asked for substantiation of what those costs were. And we provided it. A gentleman named Rich Townsend, who's an auditor in the construction industry, was working for the owner at the time, and he received and reviewed that documentation over the course of the project. So with respect to their need to see anything additional, we don't think profits has anything to do with it. We think that the fixed labor rate is, as described, fixed and not subject to audit. And we think that it's somewhat of a mischaracterization to suggest that this is a liquidated damage in the same context as those that would be available to an owner for late delivery.
So I'm looking at this request 21. I agree with you on profits and income and losses. The question I have is for expenses. I could see an argument, at least some of the expenses may need to be produced. And I'm not 100% sure on that. I don't know what loan assets really means in this context. So, but I can see how they may need to know. Yeah, I can see possibly expenses. Why? Tell me why not expenses?
Well, I think on the issue of expenses, it goes to what was already provided. In other words, during the project, they asked for the backup for our general conditions in the context of reviewing various change order requests, and we gave it to them. So they have it.
All right, I'm going to allow expenses. So I'm going to sustain the objection as to everything except for as to expenses. And then you're going to have to produce related to expenses for work on the project.
Okay.
For number 22, what is the difference between 21 and 22?
They're the same. One is the projected at the beginning of the project versus the actual expense.
22 is sustained. The objection is sustained. What's the next one?
46 is the documents showing the backup for what they actually paid. Checks, right. Bank records, something like that.
That objection is overruled. You need to produce that.
Your Honor, what we've produced is our job cost reports. There are a number of them that were generated over the course of the project, and those have been provided to opposing counsel. Not only have they been provided, but they asked us to specify by Bates range where they are in our production, and we did that.
Your Honor,
the idea that we would have to go pull every single check that was paid on this project, that's unduly burdensome.
Okay.
Your Honor, may I respond to that? And we're going to have a witness who is available on here, and we'll do that in a minute. What they produced were summaries. So that it's like getting a summary sheet without giving us the backup data. And that's the first problem with what they produced. They didn't give us the detailed job cost reports. And the second thing is the Bates numbers that they referenced were not the documents that they say they referenced. And so now may be a good time to bring Mr. Vince Chapman online and let him testify.
I don't know that I have time for that. So if I need any testimony, I'll let you know. So let's go. Let me parse through this 46 real quick. Please produce all documents, including checks. I agree that's probably too broad. Probably. Invoices, that's fine. Invoices need to be produced. Account balances for this, I assume for this project, I think is probably okay. Bank records is for this project, I guess, maybe okay. I'm
Your
not.
Honor, can I just ask a point of clarification? I apologize
Sure.
for interrupting you. It's my understanding, and I'll need to confirm this with the client, but I don't think there's a separate account for this project.
Okay. Well, how did you keep track of the project then? There's got to be something, right?
Well, I mean, you have accounting records, but I don't think you have a separate bank account that reflects that's solely this project.
Then they can redact out what, I mean, it had to have gone into a bank, right? There has to be a bank involved.
I'm not suggesting anything otherwise. I'm just saying, I think it's all commingled with the other project.
You're able to redact out bank if there's something, if there isn't a separate account for this, then you can redact out stuff. But I think bank records or checks need to be produced, something that will show that you actually paid these things.
Okay.
And then amount you paid for labor, material, equipment, tools, construction equipment, machinery, water, heat, utilities, and transportation. Is that all relevant to this particular dispute? I just don't know enough about that.
It is, Your Honor. It's anything they're claiming as the cost plus fee agreement would determine what they were entitled to receive as payment on the project. And we can't match up their claim for damages if we don't have what they were entitled to receive as payment on the cost.
I guess my question is like water, heat, utilities, was that all things that were part of this project? I guess if it's part of, if it's not, that's fine. 40s, all of that is fine. Okay, what's the next one?
The next one relates to the actual amount paid for the work for the laborers. And, you know, I understand they have that provision that I've showed you earlier. One, we think they waived it, but two, section 12, I believe it, you know, the contract is ambiguous. One side, they say you can inspect, another side, they say you can expect everything. And this is the provision that lets us inspect it or audit everything, especially if they're going to file a lawsuit against us and say this is, you know, you can't question what we're claiming as damages. It's almost like, you know, it's almost like we're going to use it as a sword, but also as a shield.
Can you show me the provision you're asking me to rule on, please?
Yeah, well, yeah, this is one of them, and then there's
what the I'm sorry, not the provision, the request that you're asking me to rule on.
Oh, it's yes, Your Honor, I'm sorry.
And Bill, do you mind, since you're driving, do you mind showing the provision that says it's not subject to audit?
Yeah, I've got that right here. Let me first show the request. I thought I had that up. Well, oh, it's right here, Your Honor. So the next one would be 52. The amount you paid for work performed by the following class of employees. And we list all of these employees that they are attempting to charge us labor rates for. And the section that they're relying on, Your Honor, is right here under cost of the work. And it's in this section here. And I'll let you read that. I'll get it all on the screen. Hold on. Yeah, starts right here and continues. This sentence is the one that says you can't audit it. It says they're mutually agreed fixed rates. It may not be adjusted for the duration of this agreement and are not subject to adjustment or audit.
It's referring to attachment D1. What is attachment D1?
That's a list of our people that are staffing the job and the labor rate that we have associated with each one of those people.
I can show you that, Your Honor.
All right, so I get it. So you can't audit the amount that's being paid. You can't audit how many hours they are allegedly working. Is that?
That's right.
That's what the contract said, and it's limited to the duration of the contract, first off, and second off.
All right, so I'm going to go ahead and sustain that objection.
Okay.
Go to the next one.
Now this is the one about time spent, and I think we do get that under.
I think you're right. That objection's overruled.
All right. I think, Your Honor, that's all the requests we had for today.
Right. All right.
Now, let me just check with Mr. Gavito and make sure. Mr. Gavito?
Well, yes, Your Honor, if I may, there was just the issue of a detailed job cost ledger, and that was the purpose of having Mr. Chapman here today, was to explain that he has requested that detailed job cost ledger in prior audits of Hill and Wilkinson, not this job, but others. And when he asks for that detailed job cost ledger, he gets it without question. And it's something that can be very easily generated with the accounting software that Hill and Wilkinson uses.
Is that something that was requested?
Yes, Your Honor.
Where? Because I don't think I've seen
But
it.
it's a report that would be responsive to request for production number 21 with the actual, and then it's not profits, income, losses, or it's expenses.
Your Honor, this is the document I referenced earlier that we've produced those that exist. And I would just note for the record that Mr. Chapman is not designated as an expert in this case. He was not involved in the project in a factual, in the sense that he's a fact witness.
What was this thing called?
A detailed
cost report.
A what?
A job cost report.
All right, that's going to be ordered to be produced in this case.
So
we're talking about
the question is,
detail,
we have to create a new one. If
it exists.
We produce those that exist, Your Honor.
Well, here's a problem with that, Your Honor. That accounting system will produce a detailed job cost record. It's not like they have to go out and they produce it in other cases. They've given it to us, and not us, but Mr. Chapman in other cases. So there's no reason they couldn't give it to us in this case. It's the detail. What they gave us was a summary. It says like concrete, whatever. I'm not sure. I haven't seen it, but it has a broad category, but we can't check to see what the detail is under that category. It's just a summary. It's like a summary that you would use in evidence that summarizes voluminous other records. We have the summary, but we don't have the detail. So we can't challenge any of their detail. Like if it's whatever, I'm going to use a simple example, 100 feet of lumber, we can't challenge that with a summary that says lumber $50. And if it's 100 feet and it really should have been 70 feet, well, we can't challenge that if they've only produced a summary of it. And that's why we want the detail. And that's why we have Mr. Chapman here to tell you about that.
Okay. I guess I'm just looking at this. They don't have an obligation to create a new document. So I've ordered everything that's in existence to be produced. I'm not going to order them to create new documents. Mr. Bain, if you could go ahead and produce an order for me on this.
Yes, Your Honor.
Sure that it says that this at the beginning, that it says this was heard on July 10th, 2023, not on this date, but on July 10th, 2023. You can go ahead and share that with Mr. Slates before you submit it to me. I'd like this order no later than this Thursday.
Yes, Your Honor.
Okay, guys, you have a great rest of your day and we'll see you soon. Okay.
Thank you, Your Honor.
All right. Thank you.
Your Honor.
Hope you feel better.
Thank you, Your Honor. I'm sorry for the interruptions.
No problem. Okay. Our next hearing is on, is there anyone here in Christus Health versus Kirkpatrick? I don't think there is.
Your Honor, may we be excused?
You may be excused. You have a great rest of your day.
Thank you, too.
Your next hearing we have here is on Elm Creek Investments versus Real. Or is everyone here in that case?
Yes, Your Honor, on behalf of Elm Creek.
Yes, Your Honor, on behalf of the counter plaintiff, Mr. Rao.
All right, Tony, let's go on the record on DC 232616 Elm Creek Investments LLC versus Monte Real. Counsel, make your appearances.
Your Honor, this is Mackenzie Wallace and Nicole Williams for the counter plaintiff, Monty Ryle, and derivatively on behalf of the other entities.
Sean Lemoyne on behalf of Elm Creek Investments.
Michael Gardner on behalf of Michael Montgomery and Highgrove.
Jeff Mills on behalf of Elm Creek Investments.
Sam Johnson on behalf of the Black Swan entities and Hard Six Holdings.
Okay, let's go ahead and proceed.
Thank you, Your Honor. May it please the court. Ms. Williams and I will be splitting.
Wait a second. Your sound went out. You muted somehow you got muted.
Okay, am I unmuted now?
Yes.
Thank you. Ms. Williams and I will be splitting the issues this afternoon. I'm going to cover the background, both factual and procedural, given the conferences that occurred. And Ms. Williams is going to cover the legal argument in support of the TCPA motion. To help you with frame and context briefly, I'll begin with an organization chart of the parties. Because
Are we hearing the issue? I didn't think we were hearing the TCPA motion today. We're just hearing whether or not we need to discuss it. Okay.
Yes, Your Honor. Because we have so many acronyms, I find it helpful to highlight that TCJ was the entity that was created by Mr. Ryle and Mr. Montgomery back in 2008. And the dispute here is actually focused down at the bottom at the Elm Creek level. And we refer to Elm Creek throughout many of the motions as ECI. And Mr. Montgomery, Mr. Williams, and Mr. Chalupa were the managers of ECI, and Mr. Montgomery contributed all of TCJ's assets to ECI. And the allegations from the counter plaintiff's petition are that the managers breached the related agreements and their fiduciary duties and their roles as managers of ECI. As a reminder, this dispute began back in October of 2022 when Mr. Ryle filed a Rule 202 petition against the managers and the entity. In February, ECI then filed a declaratory action against Mr. Ryle, our client, seeking to establish that the ECI agreement was entered into with authority and that its managers were properly authorized to act on its behalf. Now, we'll get into the relevance of these org charts in a little more depth, but the first org chart really highlights the necessity of the counterclaims and the third-party claims against the over 80 defendants and the complexity of the entity structure created by the counter defendants. And we'll also discuss in additional detail that this organization chart with the green reflects ECI and many, though not all, of its subs. And we highlight the green subs because they were contributed by TCJ to ECI when ECI was created. But those entities and the properties that they hold are former TCJ properties. If we move to the next slide, in April, Mr. Ryle, the counter plaintiff, filed his counterclaims and third-party claims. And then on April 21st, admittedly earlier than permitted, Mr. Ryle served his first set of discovery only on ECI, the entity, and later sought agreement that the discovery would be deemed served on the 11th, the date that it would be permitted. Instead, ECI refused and on May 11th filed its TCPA motion, and then the 68 counter defendants filed the 91A motion. In early June, the 68 counter defendants filed the first amended petition and their MSJ. Then in June, they set that partial motion for hearing later in June. And on June 16th, this court heard and granted a motion to continue that June 30th MSJ hearing, finding that some portion of discovery prior to the MSJ hearing was proper. Thereafter, Mr. Ryle filed his TCPA discovery motion and amended counterclaims. On June 26th, ECI reset its partial MSJ hearing for August 7th without agreement and without the real ability to conduct discovery before that date. And then on June 28th, ECI filed its supplemental TCPA motion and response opposing any TCPA discovery. Last week, we sent a letter to opposing counsel attempting to clarify and to reach agreement with counsel as to the nature of the supplement and the alleged stipulations included therein, and we've not received a response. Turning to the TCPA motion, it's important to highlight that the basis for the TCPA motion is the right to petition, and that the right is allegedly based on two letters. The first, the January 16th letter to the TCPA motion, which is a letter from ECI's counsel to me regarding the production of some documents pursuant to an agreement when we were seeking to mediate. And that's the 10,000 or 11,000 pages that we've discussed in multiple other hearings, Judge. And then second, the March 29th letter to the TCPA motion, which is a letter from ECI counsel to Mr. Montgomery on the eve of the phase 1 of the arbitration, wherein ECI posited that ECI is not subject to arbitration jurisdiction. Importantly, in counterplaintiff's view, this is a stretch of the TCPA's right to petition. ECI claims that some of Ryle's counterclaims are, quote, based on or in response to the rights claimed by counsel in these letters. And that context is important to the discovery that we're going to get to. ECI's original TCPA motion, which we understand remains live unless it's withdrawn, challenged each and every element under the second step of the TCPA, placing the burden on Ryle to prove each of the elements. And those claims that are challenged are tortious interference, wrongful denial of access to books and records, and knowing participation in breaches of Montgomery's fiduciary duty to TCJ and to Ryle. As this court is aware, there are 3 steps in the TCPA process, and steps 1 and 2 were raised under the original TCPA motion. Importantly, if we look at the exact language of the original TCPA motion, the last sentence of this snippet, while ECI does not waive any defenses to the subject claims, ECI does not raise any such defenses or grounds here. So ECI didn't challenge anything under the 3rd step, no affirmative defenses or other legal grounds for dismissal. Ryle, after attempting to confer with ECI and no agreement being reached, filed the motion for discovery and asked for the following: 1, standard deposition of Mr. Williams in his individual capacity and in his capacity as a corporate representative of ECI, or ECI could designate their own representative for a second.
I guess I still don't even understand what the basis of this TCPA motion even is. Like, how is this a violation of the right to petition? And the courts have been really restricting the TCPA, rightly so, in my opinion. How is this even a TCPA? I don't even understand how this could ever be a TCPA motion.
We wholly agree, Your Honor.
I mean,
Your Honor, if I could address that from the legal standpoint, I'm going to get to the law later. We do agree. The problem is the case law says that we cannot wait and have the hearing to find out if step 1 is met or not. And then if it is met, only then proceed to show our prima facie case. The burden is on us in our response to not only dispute the right to petition, but also to present the prima facie case in case we're wrong. And so the case law seems, sorry, Your Honor, go ahead.
No, I get that. Isn't there a new Supreme Court case out about the TCPA that talks about frivolous TCPA motions? Does that impact this at all, or?
Yes, Your Honor, we think it does. And part of what we're going to talk about with this supplement that they filed is the supplement's not truly a supplement. It's meant to completely change their motion into something else, which we think is improper and shows that the purpose of this wasn't to bring a real TCPA motion, but simply to stay discovery and delay this proceeding. So we are going to talk about that, but also the procedure is really unclear now. Even if we move to strike the supplement in our response, which we intend to do, it appears as though we still have to address both here today, and we still have to assume we might have to show a prima facie case.
Mr.
And
Lemoyne,
so that's why we're proceeding.
is the supplement intended to replace the original or simply to supplement the original?
Well, it's designed to supplement it by stipulating that these are the only things that we're moving on, which is whether or not TCJ is a member of ECI based on the pleadings and the factual allegations raised by the counterclaimant.
So you're amending it then? Not because supplementing to me is you're adding on to, as opposed to amending, which is you're changing. Am I wrong on that? Maybe that's how
Well,
I did it.
I mean, I thought about structuring it as a stipulation because I was trying to avoid this discovery fight. And so whether the court calls it an amendment or a stipulation, I think is kind of a distinction without a difference. If the issue of can you amend or supplement your TCPA motion after the initial 60-day deadline is run has never been addressed by any court of appeals that I know. So it's a novel issue of law, but we'll obviously have that discussion.
Was the supplement? So just so I'm 100% clear in this, you're essentially withdrawing the original motion and supplementing it. The only thing you're actually pursuing is the supplemental motion.
Well, now the supplemental motion just says we are stipulating that this is the only piece of the causes of action that we are challenging. So the original motion, if you looked at it, Mr. Real's counsel will be right. They would have to meet every element. And I told them at the outset that wasn't my plan, that we were going to amend it down the road. And so then we just got into a bunch of other fights. And so then when I did supplement it, I supplemented to say, this is the only argument we're advancing.
And this was and that argument was in the original TCPA motion.
Well, it would be in the original TCPA motion because it would be one of their elements. An element of books and records is you have to prove that you're entitled to books and records.
All right, I get it. Okay.
Your Honor, can I respond to that last statement though, because we don't agree that that's correct.
Okay, go ahead.
They have called this a clarification of the original motion and saying that they're stipulating, but I will jump ahead here's what they're trying to stipulate, which number one, Mr. Ryle doesn't agree to. And Ms. Wallace was about to allude to the fact that after we got their supplement and had a chance to look at it, we sent them a letter and said, we don't understand this. This doesn't seem like a clarification. We need you to stipulate with us that we're actually relieved of our burdens on certain elements under the TCPA, and that you are not asserting a step 3 grounds, because they've attached evidence to this supplement and they've made a legal argument citing evidence and case law. That's not part of step 2. That's a step 3 affirmative defense and legal grounds argument. They don't get to submit evidence for our step 2 prima facie burden. And if you look at what they've said here, they've tried to couch it all as elements to make it look like it's not a step 3. But what they've actually done here is turn this TCPA motion into the MSJ motion that Your Honor moved. So they're stipulating that the only element that they're challenging is whether TCJ is a member of ECI. First, that is an element of books and records. That is not an element of knowing participation. It's not an element of tortious interference. They listed the elements in their original motion. They're not there. We have case law on that. But even as to books and records, and it applies to all of them, you can see they're not just putting us to our burden on whether TCJ is a member. They're asking the court to consider, based on Montgomery's failure to obtain the consents required under the TCJ operating agreement. So they're essentially trying to make this argument they were making in their MSJ that they want to take certain facts and they want to take certain case law and they want to argue that the effect of this consent issue is that TCJ is not a member. If that's even proper under the TCPA at all, it would only be under step 3. So our position is this supplement completely changes what was timely filed, adds arguments, frankly, doesn't make any sense as these are couched as elements. And so, again, we think we're going to move to strike the supplement in our response, but for purposes of right now, both motions are technically live and we're entitled to discovery if we're entitled under either. And we think we're actually entitled to discovery under both. Because one other thing I wanted, and I'm sorry, we're getting a little out of order, but I want to address Your Honor's questions. You can tell just from the live pleadings and from testimony they didn't cite that these are very much in dispute. So this first one is a piece from our First Amendment counterclaims. We plead TCJ as an existing member of ECI. We've said that the issues of this enforceability and the circumstances of how it was entered don't affect TCJ's membership status. So under step 2, we could offer prima facie evidence of TCJ's membership and they don't get to respond. The only way they get to admit this evidence and argue about what the effect of this is if they want to do step 3, and we don't think they can do that. This second part is Montgomery's live pleading and the arbitration that Your Honor is aware of. He's said that that Ryle consented or acquiesced, that Ryle is stopped or waived. He's definitely not asserting that he agrees with what ECI has said. And similarly, in his testimony, they cited some selective testimony in their response to our motion. So we just wanted to show some of the other testimony that, in fact, Montgomery very much does dispute what's going on here. All right.
A lot of thorny issues here. I guess my thought is just kind of big picture is that I kind of feel like, Mr. Lemoyne, you're trying to have it both ways here. I understand
Well, Judge,
what you're trying to do, but I feel like you're not making it clear enough what you're doing. I mean, I think if you would just say that we would draw the entire TCPA motion with the exception to these challenges, then we could limit discovery to just those challenges. But the way you're writing this is, about as a stipulation that they haven't agreed to, I just don't think that's appropriate. And again, I don't see how the TCPA applies to any of this at this point. But that's not what we're ruling on to today. I just, I have a lot of respect for you, Mr. Lemoyne, and your firm, but this does, unless I'm just really missing something, which I've done before, this does seem to border on being kind of a frivolous TCPA motion. I don't know how any of this is a matter of public concern, and maybe I'm just missing it, but so I don't want to, I want you to really think about, is this the path you want to take? But I can't force you to withdraw it or anything at this point, but I just don't see it at all. But anyway, so Mr. Lemoyne, what do you want to do at this point?
so if I could have control of be able to put something up.
Sure.
Yes. I'm going to figure out how to stop mine. Do you have it, Sean?
Yeah, I've got it. I think everybody. So first of all, and just to make it clear on the record, the stipulation says this is the only thing we are moving against with regard to the 3 claims that they brought. And here is and that's even, and the reason why I can't just agree that it amends it out, Judge, is because I didn't put any of the step 1, step 2 concepts into the supplement. All I did was they were complaining, saying that they wanted discovery. I told them I was going to amend and narrow the focus, and I did. The 3 claims that they're bringing that we're challenging are all based on access to information for ECI. The linchpin to that is that they have a right to that information because TCJ is validly a member of ECI. That's just straightforward. And I'm not, I didn't prepare to debate the merits of the anti-SLAPP. All I will say, I can say 2 things, Judge. Number one, the McLean case is the new Supreme Court case that came out. Doesn't have anything to do with frivolous TCPA motions. This is not a frivolous TCPA motion. That's the first Supreme Court case to address the right of association, and that's what it was limited to, and it's limited to the old statute, which doesn't apply here.
The blurb I read, maybe it's not the McLean, it's the one that came out last week. I think it was last week or maybe the week before. Did talk about frivolous. Maybe it's a different case, or maybe the blurb was incorrect. I haven't read the actual case.
It is possible I missed it, Judge, but I read the alerts on every TCJ anti-SLAPP case that comes out in the state of Texas. Okay. So I blog about it, so I'm kind of up to speed on it.
Probably you are.
So second, the right to petition doesn't trigger off public concern. It never has. And that's why you see legal malpractice claims getting sucked up in the right to petition. You see lien fights, Liz Pennon fights getting sucked up in the right to petition. So it's just not a matter of public concern. But I understand the court's concern. I certainly know how Justice Mulberg feels about some of the over application of the anti-SLAPP. And I will tell you that part of the reason why this claim got anti-SLAPP is because of the language that they use in their original petition. They make statements like, our claims are based on what ECI did with regard to the arbitration and what ECI did not do with regard to defending the 202 petition. So it's certainly not frivolous, and I think we have at least a good argument to get the Dallas Court of Appeals to take a look at. But I understand the court's proclivity on this. But with regard to the stipulation, and I will say it now, this is the only thing we're moving on. If the court says, and I think what Mr. Riel is trying to set up is they're trying to say, Judge, we think you ought to strike the supplement because it's untimely, which is an argument that doesn't make much sense to me, because the anti-SLAPP statute allows both sides to take discovery, and it allows for an extension because of that. So the argument they're making is, oh, you can file the motion and you can ask for, either side can ask for discovery, but the movement can never change their motion after the first 60 days, which is antithetical to what design behind the statute. Why would you allow discovery and allow for the motion in the hearing to be extended, but no one can ever change their motion? But that's not.
I don't necessarily disagree with you on that. I think you can subtract or limit your motion or narrow it down. I don't think that you can add to it.
Well, Judge, all I can tell you is
case law that says that, but to me, it's kind of illogical to say you could add to it after discovery.
Well,
60-day deadline.
Well, but the discovery allows you to extend the 60-day deadline. So, if I were to come in and say, I need some discovery because their claim is not clear, but I think it's anti-slappable, and you gave it to me because the statute allows both sides to ask for it, but then you would prevent me from using the discovery that you granted me to amend my motion. And I understand their argument. I've seen that argument advanced in courts of appeals. No one has ever addressed this particular fact pattern. But what I would say is that I am not going to, even if the court were to strike my supplement and say, all right, Mr. Lemoyne, we're going to test, you can test this at the Court of Appeals, that's fine. Go dance with Justice Mulberg on this, but I'm going to strike your supplement. That then reverts them back to proving every element. I don't want to make them do that. And I will stipulate that that's not what I'm doing, and that I won't do that. If you were to strike the supplement, then they would still, the only element I'm going to challenge when we show up in front of you, after you tell me you don't like the step one analysis, is step two, whether or not they can prove or can establish that they are entitled to these books and records. And their argument seems to revolve around, well, because we pled we're a member, that's fine. That's not how it works. Otherwise, everybody would just plead all the elements and say, that's good enough for a prima facie case. And so, and here's what the case really comes down to. They make an argument in that the operating agreement for TCJ is 50-50, and nobody can do anything with the company assets without agreement. Mr. Rial testifies in front of the arbitration on March 30th in front of Judge Ginsburg that he didn't consent. Mr. Montgomery, the other half of the 50%, testifies he also didn't consent. And this is Exhibit B to our response to the motion for discovery. So, and I didn't come up with this particular argument about the advance here and in the summary judgment. It really came from something that Judge Ginsburg kind of triggered during the arbitration. He asked a question. He said, did you see the operating agreement before the merger took place? And that's what they call it in the arbitration. It's the merger of TCJ into ECI. And the witness, Mr. Rial, says no. And then the very next question is, you're not trying to challenge the merger. And Mr. Rial says, no, I'm not. But then what happens basically 10 days later? Mr. Rial files his counterclaim, and he specifically denies that those agreements, the two agreements that effectuated the merger, are unenforceable because he didn't consent to them. And he brings a cause of action for the declaratory judgment that says those agreements are not enforceable and they're not binding because he didn't consent to them. And that raises a thorny legal question, because his lack of consent under the TCJ agreement voids those agreements. And so it becomes literally a matter of law. And I will tell you that of all the thorny issues that we have, this one's the thorniest, because I've not found a case where a member of an LLC says, I don't agree to the operating agreement, but Judge, I want you to magically make me a member, and I'll get all these different rights that nobody agreed to. And so whether it's in the anti-SLAPP motion or the summary judgment, this is the crux of this lawsuit, because of the position that Mr. Real has taken. He's trying to have his cake. I want to be a member of ECI and to eat it too. I don't want any of the operating agreements to affect me. Judge, let me just decide, do whatever I want. And so when you get to their amended counterclaim, I thought, well, maybe they would change their tune on this. No, they do the exact same thing. They say those two agreements are not enforceable. If those agreements are not enforceable, it's because there's a lack of consent, which makes them void. So what do we have? Our argument is you have nothing. You are not a member of ECI. You do not get to wave your wand and say, I'm Marty Real and not happy with these two operating agreements, but I sure want to be a member of ECI. Whether it's summary judgment or at the anti-SLAPP stage, that's the question. I mean, that's the key question in this case right now, because it impacts 70 other defendants, and it eliminates like 7 claims right off of the bat. And the purpose of this hearing is whether or not the opposing party, Mr. Real, the non-movement, has established just cause. And his argument is, I want to take a 6-hour deposition. Here's like 12 topic areas I want to depose the ECI representative on. And here's like 20 requests for production that I want them to produce, which is effectively almost every aspect of the claim. And they're doing that even though they know that both parties to the TCJ operating agreement have said there was no consent to enter into ECI. It is purely a legal question for you, Judge Hoffman. It would be no different than if Mr. Real.
Then why not move for summary judgment on this?
Judge, I did, and Mr. Real, they do not want you to decide this issue. So their argument on the summary judgment was, oh, we need a continuance because we need to take some discovery, and we can't take discovery because of the anti-SLAPP motion, to which I said to them, I will give you some discovery on this issue. Tell me what you want, because I know, and they know, that the two people that are parties to the TCJ agreement both said that there's no consent. I mean, I guess conceptually,
Mr. Lemoyne, you're a great advocate, but you have to understand from a judge's standpoint, this seems like gamesmanship, that you file a summary judgment and then you file a TCPA motion to try to close off discovery. It does make me think, what is Mr. Lemoyne afraid of? Like, why won't he let there be a summary judgment, get some basic discovery on the summary judgment and let it be ruled on? I mean, that's
Judge,
I'm just telling you how this looks from a independent outsider, is that this seems like gamesmanship. I mean, that you're trying to move forward with the summary judgment at the same time you are blocking discovery with the TCPA, when you could get to the same way if we just go through how 90% of these cases go, 95% of these cases go. Just do a summary judgment, let there be discovery, and then move on to summary judgment. I mean, this TCPA thing seems to be unnecessarily complicating thing and really causing your fact finder or your decision maker, I guess, not fact finder, decision maker, to question what you're doing. I mean,
okay. So,
I'm just telling you, that's how I'm looking at it, is that what are you afraid of? Why are you afraid of a little bit of discovery, which is, I've seen a million cases like this where you rule on a matter of law because of what's in a contract or whatever. And I've granted a lot of those, I've denied a lot of those, but right now, my gut in every one of those cases is, if there's discovery that needs to be had, I'm going to allow it. And I can't do that in this case because you have this TCPA kind of blocking motion that is keeping the case from going through its normal course. I'm just telling you.
So Judge, I would say two things. Number one, if I go back and pull the transcript from our last hearing, where on the summary judgment continuance, I'm almost 100%. I said, I will allow them to take discovery on the issues relevant to the summary judgment motion. I don't know what that is. And then you said to me, well, I can't grant that. And so I said back to opposing counsel, what do y'all want to do?
Because there was a pending TCPA motion, right?
That's right, Judge. But I would still allow them to take some discovery. I just don't know what they want when the issue is consent, and their client and Mr. Montgomery, the two people that can give consent, both say there wasn't written consent. I mean, I could put a corporate rep up, and they would say, nobody ever handed us written consent, just like what Mr. Real and Mr. Montgomery said. And that's the issue here. You could grant some discovery to the other side.
If it's as simple as that, if it really is, I'm not saying it is, if it really is as simple as that, then why are we going through this whole laborious TCPA process if the summary judgment's that simple?
Well, I mean, the main reason is because I didn't want to waive the right. That's the first reason. The second reason is if I'm successful on the anti-SLAPP motion, I get my attorney's fees. You cannot get them simply, as you know, Judge, defending a breach of contract claim. And here, I don't have a contract to defend because our argument is that Mr. Real has advanced this argument that there's no consent, making the TCJ's entry into ECI void. So, but Judge, I am 100% picking up what you are putting down with regard to the
I'm not being very subtle about it.
Yes,
so.
sir. And so
All right.
what
I'm going to do is I'm going to allow all the discovery requested. If you want to withdraw your TCPA motion and just go forward with the summary judgment, you can do that. And that would definitely, I would limit the discovery in the future to what's relevant to the summary judgment motion. But based on where we are right now, I'm going to allow all the discovery that's requested. All right, guys, anything else?
No, Your Honor.
Anything else?
No, Your Honor.
Okay, give me an order on that. Make sure it says that this was heard today. What is today? July 10th. And give me an order as soon as you can. All right, guys.
All right, thank you, Judge.
Thank
You
you,
have
Your
a
Honor.
great rest of your day.
Thanks.
Thank you, Your Honor.
Okay. Hey, Tony. All right. Do you guys have can you see all the interns now? Or is that on? Tony, I've worked together for the last 17 years.
Yay.
Yay.
I always say that.
That's why the judge doesn't have any.
Oh, whoa. Oh, wait a minute. I don't know the passcode to this. That's not, you'd have to ask Rod what the passcode is. I don't know what it is.
I'll sit behind you.
You're still on your YouTube.
Oops.